on to the next presentation, which will be back at the podium, camera, with Karen on the ethical issues in representing unaccompanied minors.
Thank you, everyone. I know we're getting late in the day. You'll be happy to know my presentation is only 45 minutes and not an hour. So I'll try to move you a little quickly to the next break. But these topics about the ethical considerations are really, as you'll hear, very factually based. I'm going to give you a lot of the rules that really form the basis for your decision making, but as you'll see when I go through it, a lot of the answers are not as clear cut as you might guess. The thing is that the rules that apply are very clear cut. The source of rules are easy to find, but it's not that easy always to answer the question. So what I'm trying to do here is give you sources of information and of guidance for yourself and talk about them in the context in which some of these questions arise, but you'll be disappointed to find that I can't necessarily give you the answer to every question because, as you can imagine, there's a big difference dealing with a child that's 3 and a child that's 15, or one who speaks English or one who doesn't, or one who has education or one who doesn't. There's a broad spectrum when you're talking about child clients, and that's why you'll see that the answers are not necessarily, and in fact typically are not black and white. So I have a couple things to say at the beginning. The first one is kind of funny for a Virginia ethics training, but I'm not admitted in Virginia. I want everyone to know I am admitted in Maryland and in the District of Columbia. I practice for the most part in DC, although I practice in immigration courts all over the country. So part of what we'll talk about is the interplay between various jurisdictional laws that may apply to you. I know that obviously this program is put on by the Virginia State Bar, but some of you may also be admitted in other jurisdictions or practice in other places. So I'll talk about the variety in some of the sources of law that may pertain to you. I want to say a word too about what led to the creation of this presentation and the focus on the rules as I'm giving it to you. You heard in the introduction that I serve as special advisor to the ABA Commission on Immigration. I also am a member of APCO, the Association of Pro Bono Counsel. That's large firm lawyers like me who run big firm pro bono programs. And it happened that in the big influx of unaccompanied minors arriving last summer and then on into the fall, there was a big push for volunteer lawyers from big firms to come in and start representing the kids. And there was a very strong reaction, a big willingness on the firms to do that. So they started taking cases and then sitting down with their child clients. And then all of these questions started to come up. It was sort of then that almost without forethought, some of the lawyers who hadn't dealt with these kind of clients or these kind of issues before began running them through their normal process. And then it was like, oh, what do I do about conflicts checks? And what do I do about an engagement letter? And then the client can't sign a form. And then what's my, the typical language in an engagement letter and the provisions for regular communication? They seem to just not apply. So lawyers began asking questions. How do I do child cases as if they're completely different, right? As if the rules governing them are completely different, and they aren't. And that's really the starting point for this presentation. You'll see here the model rule, and everywhere I refer in this rule to the model rule. These are the ABA model rules. Each state has its own model rules, and I have tried throughout this PowerPoint and in the materials supporting it to give you the corresponding Virginia rule, but as I'm going to explain, you may need to look at state rules that are other than Virginia. Anyway, the model rule, to which the Virginia Rule 1.14 is identical. Model rule is called client with diminished capacity. The Virginia rule is called client with impairment. But this is really the governing sentence for the whole thing. The lawyer shall, as far as reasonably possible, maintain a normal client-lawyer relationship with the client. Every issue that you have really harkens back to this basic guidance. That is, you have to treat your child client and maintain your relationship with your child client as close as you can to that as which you would do in any other client representation. What you'll see as we go through some of them is the rules may be applied more flexibly, or you may modify what you do based on the age, level of education, level of understanding, trauma or lack thereof that the child has experienced. But your goal is to follow a normal, traditional lawyer-client relationship as much as you possibly can. I did want to highlight here that in Virginia, although the rule is the same, some of the comments to the model rule, and you will see this in your materials, are different. The model rule has comments that pertain to taking protective action that may include seeking appointment of a guardian, the ways that you assess the extent of diminished capacity, and those comments don't apply, or I should say are not squarely adopted in the Virginia rule, but the provision about permitted disclosure to professionals and diagnosticians in particular to help you assess the child's capacity and the degree of flexibility you need in explanations and communication, that comment does carry over. So that's sort of the first illustration as we need to look at the applicable state rule. Now, there are some comments here that are instructive in both the model rules and in the Virginia rules, and I've extracted here just a sentence from the comment, and here you see it. Children as young as 5 or 6 years old, and this is in interpreting the rule on diminished capacity or client with an impairment. Children as young as 5 or 6 years old, and certainly those of 10 or 12, are regarded as having opinions that are entitled to weight in legal proceedings concerning their custody. Now, that's not talking about SIJ cases squarely or kids in immigration proceedings. That sentence in the comment is an example, and it refers to custody. So you have to extrapolate from that into the situation that we're talking about. So you sort of see the parameters in this comment as 5 or 6 and 10 or 12, and what you see in both of them is that the child can have opinions that have to be given weight in terms of what their desires are. I think the harder question is, okay, what about if you go younger than 5 or 6 and older maybe than 10 or 12? We'll go through a little more some of the ways that you help inform yourself about those abilities and inabilities, but I think the comment gives you guidance that even almost the youngest child, certainly not one that can't talk, but anybody that can give you through language, body language, some of the things that Mari was talking about how a child indicates even comfort or discomfort with people with whom they associate, can give you a clue about their comfort level, receptivity, degree of confidence, or whatever in the adults that are around them. Oh, sorry, I didn't put on the slide, but I wanted to say there is an additional comment in the Virginia Rule 1.14a. It has an additional sentence that's not in the model rule, and it says, if the person, and this is the person with diminished capacity, here a child, has no guardian or legal representative, the lawyer often must act as de facto guardian. And that bothered me a bit because in this area, this subject matter area, we're always talking about the difference between child-centered representation and your job as a lawyer to act in the express interests, stated interests of your client versus the best interest standard, which is something that a GAL or a guardian or something like that is obligated to follow. So this sentence in Virginia, and I invite in the Q&A period anybody else who'd like to address that in the Virginia rule to say more about it, but it gave me a question. Yes, it's true that often, particularly when judges call on you to identify forms of relief or answer factual questions, in a sense, you can get put in the position, at least the rule says de facto guardian, where you can almost be forced to speaking for the child, but I would encourage you in your own mind not to separate your role into moving towards that area of making the decisions for the child as opposed to carrying out those expressed by the child. So that's the point I wanted to make about best interests in that particular comment. Okay, so we've talked about the diminished capacity rule. Here's a long list of other rules, and the point here is that all of these on the list apply to the extent possible. Normal attorney-client relationship. Remember, that is the governing principle. So all of these rules apply in your representation of your child-client. That is the duty of competence, the duty of diligence, the duty of communication, and we'll talk a little bit specifically about communication, and there are some small differences in the Virginia rule on communication. Duty of confidentiality, the conflicts of interest rule, and others, including declining or terminating representation, and also your duty of candor to the tribunal. So again, it's not that you have a child client, the child has diminished capacity, so your duties are diminished. They're not. The way in which you carry them out and satisfy them may be a bit different, but you don't have a lower duty of competence, for example, because your client is a child. You don't have a smaller duty of confidentiality. No, that's not it. It's sort of like a sliding scale of on execution, but not on what your burden or obligations are. So here, I wanted to give you a quote from the Virginia comment 5, for example, on communication. It is this: a lawyer should fulfill reasonable client expectations for information. Okay, so think about what does that mean? Reasonable expectations for information. Consistent with the duty to act in the client's best interests and the client's overall requirements as to the character of the representation. Okay, to me that doesn't seem to clarify a whole lot, except that reasonable client expectations, which the smaller the child probably means their expectations for communication are not very much, and for an older child, especially things like, what do I have to do? When am I going to go to court? When do you come back? Do I have to listen to this person who's my sponsor? You know, do I have to go to school? To the extent that impacts the legal situation, I think you have an obligation to think about. Certainly, you have to respond to questions your client asks you about things that impact the representation, and you may have an affirmative duty to give them information and communicate certain things that could affect their legal interest or their entitlement to any form of relief. There's also a comment 6 in both the model rule and the Virginia rule that says fully informing the client of developments in the matter may be impractical where the client is a child. So there's somewhat of a recognition, of course, that the burden is not to do exactly the same thing as if the client was an adult, because the cognitive abilities are not the same, but the child is entitled and must receive from you information that's what they need to know or want to know. Also, I wanted to mention here to those who may be either practicing in or at times working in a different state, it was brought to my attention that in New York, for example, there's a state law where there's a presumption that a child 14 years old or older can do certain legal acts on their own, including filing a petition for a guardian. So it suggests that someone could be a minor and have diminished capacity, but there's almost a presumption of capacity, and that, so I encourage people, I did not find this to be the case in Virginia when I looked into it, but just to raise people's awareness that, for example, if there's an age at which children are old enough to sign contracts or perhaps to be emancipated, be aware of that, because it may heighten your responsibility to older child clients who would come closer on that continuum to the entitlement to information more like that an adult could expect to receive. Okay, here's where it gets a little more complicated, and other speakers have alluded to these a bit also. What other rules? So far I've been talking about state rules, but what other rules may apply? You'll see here the federal rules of practitioner conduct in the Code of Federal Regulations, and they have, and I've picked out a few of them, the same duties that we've been talking about: the duty of competent representation, the duty of diligence and promptness, the duty of communication with a client, and you can be sanctioned by the immigration authorities specifically, and not only under state law, for violating any of those rules. There's one in particular, and that is the duty of communication with a client under 102R. That's especially relevant here because these are rules of representation in immigration proceedings. There is a rule there that says the duty of competent communication includes a duty to communicate in a language the child understands, which means that you either have to speak the same language as the child does, or you have to associate yourself with an interpreter, or if we're talking about documents, a translator who is fluent in a language the child understands. And that's one more thing that can't be short-circuited in the duty of communication. And here, in this particular rule, it's made explicit. The communication has to be in a language that the child understands, and that's your burden to make sure that that happens, or you can be sanctioned for not doing that. Other state professional conduct rules, I'll talk about this a bit more on the next slide, but it's possible not only that some rule other than Virginia for purposes of this presentation, but you may actually be in a situation where more than one state law applies, and you need to be mindful of that as well. Okay, here's one that comes up a lot, especially for newer practitioners. How can I practice in immigration court if I'm not admitted in that state? You heard a bit about the forms used for entering your appearance, but the general rule, and I'm talking here about appearing before USCIS or the Executive Office for Immigration Review, the immigration court, to practice before those administrative agencies, you do not have to be a member of the bar of the office or the physical court in where it's physically located. You have to be, to practice before those agencies, a member of the bar of the highest court of any state. I've cited here to the EOIR form, EOIR 28, that's the immigration court form. There's a comparable form called the G28, that's for use with USCIS. And you'll see the box where you enter your appearance. It will either say, as a lawyer, I'm the member of the bar of the highest court of whatever state, and you have to fill in the name of the court and the state there. Or I'm a law student, or you know, somebody else appearing at the request of the person. But it's the top box where you indicate your bar admission, and you also have to say whether you're sanctioned or subject to any discipline there, and there is reciprocal discipline between EOIR and other jurisdictions. So yes, you can be a Virginia bar member and go practice in Maryland, or for that matter in Los Angeles or Connecticut. You can appear telephonically in Texas, assuming you have permission for a telephonic appearance. Your state bar membership doesn't govern your appearance in agency proceedings. It does, subject possibly to exception of pro hoc vice rules, state bar admission does govern your appearance in state court, in the family court, probate court, or juvenile court proceedings. Which state's disciplinary authorities could act against me? Potentially several, and I say this again not because I can answer the question, but to have you be aware of this. You can always be disciplined by the state in which you're admitted, and it's very important that you know the ethical rules on all of the issues that we're touching here. If you're admitted in more than one state like I am, you have to know those. Also, the state in which the conduct at issue occurs, potentially those rules apply, and the jurisdiction of the court or the tribunal where you're going to physically appear could apply. And here you'll see this comes from the model rules, the state where the predominant effect of your conduct will occur, which usually overlaps with one of those others, but you can conceive of situations where it might not. So you do have to know the state laws that pertain to you. And in general, just as a practice tip, if you find yourself having to reconcile various state laws, for example, here's one that I have a lot. I'm admitted in Maryland and DC. I may be representing a kid who lives physically in DC, but his immigration court proceeding is in Virginia, okay, in Arlington. Which rules do I have to worry about? And the answer is all three. And the safest thing to do, to the extent that there's overlap, is not look at the rules with a view to, you know, how far can I go or what can I get by with, but what is the most conservative interpretation that's going to protect me from discipline. If you do the one that's the most conservative, that, you know, falls within the scope of what's permissible for all three, then you obviously can't get into trouble for violating the rule in any of them. I wanted to mention too that EOIR has its own disciplinary process. I showed you the rules before. A judge can make a complaint about you or refer you for disciplinary inquiry, as can any of your local bar authorities report you to EOIR, even if it has nothing to do with immigration practice. If you've been sanctioned or disciplined in some other case for something that you did in a probate proceeding, a divorce contest, whatever, if you have been have restrictions on your ability to practice, they can notify EOIR, and EOIR also checks periodically for lawyers who practice before them to see if there are any disciplinary proceedings. So all of those things come into consideration, and you have to make sure that you're operating consistent with all of the various rules that pertain to you. Engagement letters. This is one of the most frequently asked questions. I alluded to it earlier with the big firm lawyers freaking out, right, about do I need an engagement letter with a child client? First question, must I do an engagement letter? And a typical lawyerly answer, I'll say it depends. It depends, first of all, on state law. In DC, where I practice most of the time, there's a rule that you're required to have a written engagement letter in every matter, regardless of whether the engagement is pro bono. You're required to have an engagement letter. So we have to think about, what does that engagement letter look like in a child-client case? I looked at, and I invite correction on this if I'm wrong, I looked at the Virginia rules, and what I found was not that there's a law requiring engagement letters, but in general, engagement letters are viewed as a best practice. So there, if I'm correct in that, my practical guidance would be that whether you should have one, given that in general they're a best practice, would depend on the answers to some of these questions. Does the client's age make a difference? What about language? We talked a bit about the ability to understand the letter. So do you do a letter in another language? Do you do a letter in English and have it be translated? And what if you have a child, regardless of age, who can't read? And I would say there, this comes back to, we have adult clients who can't read or can't read in English also. And what we typically do is you do a letter either in English and translated or in a language that they understand, and you use a certification that's been read and translated to them orally. So they don't sign necessarily the letter, or maybe they make a mark if they're able to do that. But the key thing is that the interpreter attests that they have translated the letter orally, and the person has acknowledged their assent or fixed their mark or whatever is actually appropriate for the factual situation that you. if there's an adult, and this question started to come up earlier about an adult in the room, and I've raised the same question here about whether an adult should be included on the engagement letter. And I'd say the starting point for this analysis is what's the relationship of the adult to the child? Does the adult have legal authority to act for the child, which is in part a function, again, of how old the child is? If the adult is the child's legal guardian, clearly the adult can contract, which would mean sign an engagement letter on behalf of the child. If the child is a parent and their rights are not terminated, they're the natural guardian of the child, so they could sign on behalf of the child. But what if they're not? What if they're a GAL? What if they're a family friend? What if they're the aunt or uncle with no legal relationship? What if it's a school teacher? And again, how old is the child? What's the child's own level of understanding? And I think this is really a balancing test between the child's relationship with and reliance on that adult. I analogize it in part to an interpreter, where interpreters come within the realm of your protection of confidentiality. Is this adult so close and so trusted that the child client can't communicate, can't engage in communication without this adult? Then maybe that doesn't breach confidentiality, and maybe you want to have that other adult sign at least an acknowledgement that they were present when the child consented to the terms of this. On the other hand, if the child is old enough to sign or consent on their own, I think it's much more tricky about bringing in another adult, and you risk breaching confidentiality and maybe not even having a protected relationship if you have too remote of an adult with too old of a child in the room. So again, I apologize in a sense for not being able to give hard and fast answers, but I think it really is a case-by-case determination what you do with adults in this situation. Here are a couple other points on this question of adults. Even if an engagement letter is not required, how could you or how might you confirm your representation? Because of course you wouldn't be filing your engagement letter with the court in any event. You do, as I said before, enter your appearance before USCIS on a G28 or an EOIR 28 if it's immigration court, and that form provides for a signature by the client, which would typically be the child. There is the regulation here that I've provided for you, 1032A2, that says a parent can sign if a child is under 14 years old. Certainly a legal guardian also could sign on behalf of a child and acknowledge that, and I think that would be correct at any age. But if you have no legal guardian and not a parent with the child under 14, practitioners take different approaches. Sometimes they say signature not required. Sometimes they have the little kid print their name, the best they can. You're going to get Eliza or something like that in capital letters, and that's it. Typically, your form doesn't get rejected over a lack of signature, but it does reflect a bit, the capacity of your client and the way you regard your representation and how they relate to you. Okay, I have about 10 minutes left. I wanted to address a little bit legal guardianships, where they fit into this picture when you might or might not want to use them. First of all, there's no direct authority under the Immigration and Nationality Act for appointment of guardians. There's technically no regulation that allows an immigration judge to appoint a guardian for a child. Typically, guardianship, legal guardianship, if there is going to be one, needs to be done in state court. The ethical rules, and we've gone through some of these before, suggest that in certain circumstances a guardian could be helpful. But that's, you have to think through whether it would be helpful in your case and how you would go about getting one, if in fact you thought it would be helpful to you to have one. Remember, first of all, that the parent is a natural guardian, so if you have one parent with legal authority, perhaps you don't need to get a legal guardian, but there you have to think about whether the parent that's in the picture again, depending on the age of the child, whether that parent actually does speak for the child. Sometimes the parent that's nearby or in the picture is abusive or otherwise detrimental to the kid, and your child client doesn't want that parent acting, so you may want a different legal guardian. Another situation that I can think of where a guardian may be necessary, and this happens often in border situations. Kids turn up, you know, in or on the river or the riverbank, and they're 2 or 3 or 5 years old. Maybe they know their name, maybe they don't, but they're unable to articulate biographical history, any parts of their story, how they got there, what's happened to them. I've seen siblings 18 months and 3 years old. Your factual history you're not going to get other than where they were discovered. So you do need somebody to be able to do an investigation, articulate desires and preferences for them. And that's a place where I think having a guardian appointed would be very helpful. When might they be useful? Sometimes even when you have a child, an older child, who can articulate their wishes, and your obligation and your representation is to follow those wishes. But sometimes there's a rub because you think that your client, to put it simply, is making a huge mistake. Sometimes they're being seriously affected by somebody who doesn't really have their best interests at heart. Sometimes you'll get the 14-year-old girl with the 22-year-old boyfriend. Maybe she's living with him. Surely he's telling her what to do. She may be very clearly able to articulate to you what she wants. You have a duty of confidentiality towards her unless your state law requires, you know, report of a certain type of abuse. But maybe it's her uncle. Maybe you just have a bad vibe, right? And you're reluctant to proceed with advocating her wishes without some outside assistance. That's a place where seeing about the possibility of a guardian or a guardian ad litem to get somebody else to be able to actually articulate the child's positions could be helpful to you. Sometimes you want a guardian in the case because it'll make something else in the child's life easier, not directly related to the immigration matter, but maybe they need to get enrolled in school or get an ID or get a passport or request a copy of the birth certificate or something like that that they can't do without a legal adult guardian. So you may want to pursue a guardianship for that. What problems would a guardianship not solve? If you have a guardian whose wishes are squarely at odds with those of a child client, or you have a guardian empowered to make decisions on behalf of the child, but your child has told you some facts where you're under your duty of confidentiality, you can't disclose them to the guardian, but you know that the guardian, uninformed by those things, is not doesn't have the full range of facts on which to make a decision. So there are cases where a guardian doesn't perfectly resolve the situation. There's one quote I want to give you, and this is borrowed, very literally borrowed, otherwise classified as stolen, from the KIND training manual for pro bono attorneys. But this is a paragraph that I think is helpful here. Each attorney-client relationship is client-driven. This is true in the case of child clients as well. You may not be accustomed to dealing with children as clients. It's important to remember that your role is to advocate for what the child wants, even if what the child wants is not, in your opinion, the most appropriate decision. The child has the right to participate in the entire process of her case. It's important to ensure that the child understands that she has some control, such as over where to sit, when to take breaks, or what to talk about first, as you heard from Mari. This child-centered approach not only increases the child's feeling of security and control, but also contributes to the self-empowerment of the child. So again, that's your starting point. That's the general rule, but there are situations where following that approach, you know, it is actually going down a very dangerous path for the child, and that's where I'm suggesting that you may want to or need to consider, if your state law obligations allow it, considering the appointment of a guardian. Okay, conflicts of interest. I'm just going to say a couple words here because I'm running out of time. Direct conflicts of interest are obviously prohibited under all the laws. That doesn't usually come up in this context. You can't represent one client in the same matter and another basically on the other side of the V. That's not what's going to happen. Positional conflicts, although they're not squarely prohibited, should be avoided. And those are ones where you may be taking a position in a matter that's at odds with a position that would be taken by another client. Here, I can see this sort of coming up if you or your firm represents the state of Virginia or the Child Protective Agency or possibly somebody else involved in the matter. This particular case may not be the best one for you to do. I can also think of positional conflicts if you had siblings or maybe cousins, friends, somebody that traveled together, even kids together in shelter care, maybe a boyfriend and girlfriend who traveled together, where some version of the facts somewhere along the way you may anticipate could pit one of them against the other. They may have differing factual versions. That's something that I would also try to avoid, although it's not prohibited in the sense of a direct conflict of interest. The bigger one that I see here is the context of joint representation. You have to watch out for conflicts between parent and child, custodian and child, sponsor and the child client, and particularly, and in some places it's not even allowed, but representation of a child and a parent where maybe in the state court proceeding you're representing the parent, the aunt, the grandma, whatever, and then later, but in reality, simultaneously, you're recommending the kid with the eye on the ball of what they're going to do in their immigration court proceeding. It can happen a lot in those situations that a difficulty arises, either a conflict in the way you want to pursue the case or a conflict just in day-to-day practical operations. Somebody's run away from home, or the judge is asking you where the kid is located, or the parent is making the kid work and not go to school, and you can get involved in a situation where you're called upon to tell, like, what's going on in the case, or where is the child enrolled, this or that. So there, I think it's very, very important to evaluate carefully whether you are going to undertake a joint representation at all, and if you are, to be very careful that your engagement letter clearly provides when you would need to withdraw from representing one or the other or both if these kind of conflicts arise. Also important in a joint representation that both parties note that you cannot conceal facts from one another that arise during the course of the representation. All of which are things that cause me to say joint representations, while not impossible, present big red flags, and you should go into them very carefully and with your eyes open. The last thing I'll say about conflicts here is that it is permissible for a third party to pay. I know we're here talking about pro bono, but sometimes in the SIJ context, a parent or a family member is able to pay for that representation. Remember, that's permissible, but if they do, the person who pays does not have the right to control the representation. They're not your client, and your child client is the one who dictates the terms of the representation and makes the decisions, and has a right to information. You'll often encounter the person who pays wants to know all the things along the way, what's going on about the case, or wants to tell you to apply for asylum and not SIJ or whatever it is. Unless that paying adult is also within the scope of the representation for the reasons I've previously discussed, that person is not entitled to have information or control the decisions in the representation, and you need to be mindful of that. So I have one last sentence, and this comes from the scope of the model rules, and it's basically equivalent under the scope of the Virginia rules, because this can sound very technical and that it can be very difficult to make the correct decisions. The scope tells you the rules of professional conduct are rules of reason and are to be interpreted with references to the purposes of the representation and the law itself. That makes me feel a little bit more comfortable when I'm having these dilemmas with myself about whether I need to go this way or that way. Rule of reason designed to advance the representation. I think you're unlikely to get disciplined if you're engaging in pro bono representation of a child if you don't squarely run afoul of one of the other laws that we've talked about, but your duty is to know the rules and follow them the best you can. And then on finding a safe harbor, I just wanted to end up by saying you have an ethics hotline always available to you at your state bar. Most law firms have an ethics counsel or general counsel. The referring organization typically has supervising or mentoring attorneys who are available to help you out in walking through some of these ethical dilemmas when they happen. Documenting, if you do find yourself in a situation where you need to take those steps to help you make a decision, document it. So if anything ever does arise, you show that you've taken diligent efforts to help get guidance in the dilemmas that you face. And again, remember, if it's unclear, take the safest, narrowest course possible. The last thing I'll say is I put in your materials the relevant model rules, the Virginia rules, and what I consider to be a super helpful handout. This article, Ethical Issues in Representing Children in Immigration Proceedings, this was prepared by the American Immigration Lawyers Association in collaboration with the ABA, and it was done in response to the compilation of a group of those frequently asked questions that I mentioned the big law firms were generating when they first started getting involved in this work. So where I've presented this as sort of a walkthrough of the rules, this is more like response to FAQs in a narrative fashion and can be quite helpful to you in facing some of the questions that I've talked about. Okay, so I think that's everything for me.